They need to understand what AI is today. They need to understand it is task specific. They need to understand its pattern recognition tool. And not everything needs AI. And if you need AI, it has to be done in a sensible manner.
Hello and welcome to Superlawyer YouTube channel. And once again, we are here with a phenomenal personality called Vibhav Mittal and a very dear friend. I have known him for more than a couple of years now. Welcome, Vibhav. Thank you for agreeing for this interview. And yes, I should introduce him as partner at Anand and Anand. And other than that, he will carry forward with his own story. And I would request you to tell us about your journey into the legal field, how you decided to become a lawyer, especially in intellectual property rights, which you are fascinated about and have made a name. What inspired you to specialize in such a niche area? And please take us through your journey. Welcome, Vibhav, and thank you.
Thank you so much, Divya. It's an absolute pleasure to do this with you. And I think I'll just start from the really from the beginning of my journey. So my parents are actually doctors, and there's a very conventional thing about Indians, doctor ka beta doctor, yeah, engineer ka beta engineer, right? So my father actually told me very clear cut ki beta engineering to nahi ho payegi. So you won't be able to do engineering. So then it was between medicine or trying to do some other profession. I honed in on law because at that point when I was making the decision, it was more based on elimination than anything else. So I didn't want to do engineering. I thought of medicine, but was not so sure. Both my parents are doctors. They cast very long shadows. They are very successful in their own right. So I felt, okay, let me then stick to law because that way, when I do law, I can move to journalism. At that point, I was very interested in that. I was very heavily involved in theater when I was in school. So I therefore also felt that there are some laws around the theater and playwrights and all. So maybe I'll get a chance to do that, journalism. Or if nothing else, I may even like to do an MBA after law school. So from that logic, I just sort of in the process of elimination and keeping my options wide open, I decided to do law. And then basically what happened was that now having had made up that mind, I then decided to do the coaching. So in class 12 itself, even though one was busy in class 12 boards, I started the career launcher coaching from SDA Market here in New Delhi. Now, the interesting part in that is that while I did take up the coaching, and I remember this very clearly, this was way back in 2007, 2008. 2008 is when I gave the CLAT exam and I did my 12 boards. Despite taking up the coaching, I really could not focus on the coaching because me being me, I felt that no, I can't compromise on my 12th even if I have an entrance exam later to give. So, what ended up happening practically was that I would end up focusing pretty predominantly on my class 12th exams, and then from there I would make sure for the time that I was in the law school coaching, it was every Monday, I remember still date, 5:30 to 7:30 in the evening, I would be very mindful and very present in the coaching class. So what happened was by the time I reached the CLAT exam, I had gathered a lot of understanding of how to give the competitive exam. And then I did another crash course with Career Launcher in April itself. And then I just gave the CLAT exam. It was the first time CLAT was being held. And as luck would have it, I made it to NUJS Calcutta. One thing I remember very clearly about my CLAT exam, and I realize it's become a very big exam now in that sense. So is that I remember that I had a very clear strategy about how to give the exam. By the time I reached the exam, I had a strategy in terms of I knew how which section was for how many marks, how much time am I going to give to each section, which section am I going to take up first, which section I'm going to do last. And I think I remember being very clear that what is black and white and what is gray, which means that if once I had figured out, like in reasoning and all, I had figured out some basic types, I knew that even if I did them more, I can still get the answer wrong. So I kept the black and white preparation of GK and English, vocabulary, and all up till the exam day. Rest I started doing in mocks. That's a little bit of a journey of how I went to law school in NUJS. So one was the inspiration to law, the other was how I made it to law school. Of course, NUJS was fantastic for 5 years. I won't get into too much details of that. But coming to law and then the question that you asked about intellectual property, right? So intellectual property, to be honest, one of my uncles, Ratan Masaji, he pointed out to me when I was, I think, in second year law school. I don't remember what function it was, but Indian Habitat Center ke kisi hum chhat pe baithe hue the, we were having tea. I'm kind of trying to make that scene here, like for people to imagine that we were having tea or something on the terrace, and then he was talking about some case on IP. And the idea actually, to be honest, came from him. The word intellectual property came from him. Then at the end of my third year in NUJS, this is 2011 summer, about this time, May 2011, two things happened. One, I interned with Geeta Luthra, who is a renowned civil litigator, as many may know, and I kind of fell in love with litigation at that point of time in that internship. It was very hard work, a very intense internship. I used to reach office at 10 and probably leave at 1 or 2 in the night at times, and 4 week internship, but really in the month of May, where courts start or these trial courts are still on till June, and I ended up going from high court to all trial courts in Delhi. So that was one important thing that happened. The second important thing that happened in 2011 is that I met an individual called Rodney Ryder through someone who, at that point of time, was he's still a very renowned person in that space. And I met him in CP. I remember dates and times a lot. So you'll probably hear that a lot in this interview. So to get used to it, I think. So I met him in CP. And then because of the person that he is, he shared his experience, but he also suggested a couple of books to read to understand if I really enjoy this field. And he suggested a book called Rembrandts in the Attic. And I actually have it with me. It's a very old book, but it's the book that started the process, because it's a book that talks about intellectual property rights as an asset to monetize it, and it speaks about patents. And the book was written sometime in the early 2000s in America, talking about the shift of how people viewed intellectual property differently. So I read that book in the summer, and as luck would have it, I said May 2011, I met him in May, June, July 2011, when fourth year college started, my IP courses started. So after that, after I read the book, I came to intellectual property like anyone else does by being a student. Because I was in college and studies is what I could do, I figured out my interest in this field by getting involved in these subjects. And therefore, my professors, I had Anirban Majumdar for copyright law, Vishwas Devaiya for trademark law, and of course, Shamnad Bashir was there for patent law. So Anirban sir got my interest in copyright law. And because I used to do a lot of theater in school, so that sort of picked up my interest immediately. Then Shamnad sir, when he entered the scene, that kind of changed from copyright to a lot of patents. And then Vishwas Devaiya sir kind of took it to trademark law. So three of my best faculty at that time from these three subjects. And then I became clear in terms of the fact that I want to pursue this to an extent that despite having a very good rank, I was in the top 20 of my batch. I didn't sit for placements at the end of fourth year. I continued to pursue IP. I remember very clearly in my final year of college, I think my batchmates every weekend used to go on a trip. Many of them had been placed, many of them had not been placed. I hadn't even sat on for placements, right? So that was another issue with, my mother would ask me at times that, are you sure you don't want to sit for placements? So I was like, no, yeah, I only want to do intellectual property now. It's very clear. I've read the books. I've enjoyed the course. And by that time, I had done the litigation internship. I had done a corporate law internship. And I was like, no, so I have to do it. And I'm going to circle back to this aspect in terms of maybe when we speak later about what people should do today. But it's important to understand that that final semester, last 2 semesters of my college, fifth year, I only studied. Like, not only studied, of course, but I was definitely not going on trips every weekend. I was interning. I was focused on intellectual property. I did all the courses. I did all credit courses. I did papers. I did everything so that I made sure that if my CV would read, it would read intellectual property, because I wanted that focus on IP to come out clearly, because I had not sat for placements. I was not going for a corporate job. And it was a fairly stressful time because of the fact that one has to wait that long to get any kind of IP job. And I didn't even have my current role at Anand and Anand as an option, actually, frankly, because intellectual property rights litigation is such a niche. I mean, it's a niche within a niche, right? We don't know many law firms that would hire. Maybe it's changed now, but at the time that I was looking for jobs, or I was looking for a job, the starting point for a fresher in intellectual property rights litigation was almost non-existent. So what I had made up in my mind was that I will start off with some trade, because I don't have a technical background in that sense. I would start off with a prosecution background, like a trademark prosecution opposition sort of approach, and then maybe in 2 3 years transition to IP litigation. But as luck would have it, in that year, in 2013, 2nd March 2013, Anand and Anand had a recruitment fair, and our college is invited. And this was about 40 days before my final exam of my final semester. And I got interviewed and I got selected that very day itself. My interview is a separate story. It was an interesting interview. It's part of ANA folklore now in terms of how it went. But the point is that I went in there. First round was with my current boss and his current colleagues had done it. And the second round was by Mr. Anand himself. And I remember the questions were around patent law and a concept known as person of ordinary skill in the art and everything like that. And then I just got hired. So that was perhaps a longish answer, but sort of giving you a good perspective of how I came into law and how I came into intellectual property law.
Actually, fascinating story, and how you were so stubborn on only doing intellectual property litigation. Still, we hear a little less about it because it has not become a fashion. It's still niche of the niche. And thank you for doing so that we have such lawyers as well in India who actually litigate in intellectual property. Keeping that in mind, you must have seen a lot of difference between when you started a decade ago in this particular field. What kind of changes or enhancement or advancements have taken place, even you being there, and how instrumental you have been to those changes as well? Please share that story.
So I think one of the main things about changes in intellectual property law in the last decade, one, of course, I have been at Anand since I left law school. And one thing that is perhaps important for the audience to also understand is that Anand is a pro IP firm. So we protect and enforce intellectual property rights. So we stand and protect for the IP owner, whether it be in trademark law, whether it be in patent law, whether it be in any field of law, even copyright. So an example would be that in patent law, I would stand for the patentee, which is, say, we could very well represent a cancer drug owner. For trademark law is slightly more well versed for people, so you're standing with brand owners. And in copyright law, one would say stand for an individual artist or singer as opposed to any other opposite party. So the changes that have come has been through that lens. A lot of practice in the is in intellectual property rights litigation is at the Delhi High Court. Let me give you the two, three major changes that have, like, the major changes, but from two, three lens. First lens is in terms of reliefs granted by court. When I joined, literally my first day of my job, my immediate boss gave me the 275-page judgment passed by Justice Manmohan Singh in the Roche Cipla patent infringement dispute. This was the first lawsuit that had been filed under the Patents Act of 1970 after the product patent regime had begun. So, in my first 2 years, 2.5 years, amongst other work that I did, was involved in being part of the Roche versus Cipla appeal. And for background is that Roche had lost, for a cancer drug maker, had lost before the single judge, and now on merits. And now the first appeal, the regular first appeal, was there before the division bench. And in that process, I learned a lot of patent law and did a lot of research and a lot of work. And I pretty much learned the art of really handling complex matters in that process. And so the one change that happened was that, at least from a jurisprudential perspective, is that we won that appeal on 27th of November 2015. And in that judgment, the court sort of laid down a lot of concepts of patent law and patent jurisprudence which hold true till date, especially in the context of pharmaceutical patents and generally in patents. So that's one change in terms of a shift towards a pro patentee win. That was about 2.5 years into the profession. That's on the substance. Of course, trademark law reliefs have only blossomed, and now we get costs, we get damages against infringers, and a lot of other things. And copyright law jurisprudence has also been evolving and growing. But the reason I explain this from a patent lens is because it kind of tells you the manner in which the jurisprudence evolves, because these are more gray issues of law. And another change that I can speak about, I'm now going to speak only about my personal experience, is that when I came back from my LLM, I got involved in the Monsanto dispute. This is the Monsanto dispute that happened in the Supreme Court. So I got involved directly in the Supreme Court level. That was another different type of an experience. There, in terms of my own involvement, because I had done 3 years of practice, I had done an LLM, and I had just come back from my LLM there, not only as a junior most member, but also of knowing the files inside out. So there, the issue was more in the context of patent eligibility tests, like, well, simply put, whether that invention qualifies as a plant variety or whether it's a gene or whatever. So that entire question was there. So again, the change or a positive thing in that sense is the fact that the court was able to understand the various legal issues, and the division bench's decision was set aside, and sort of it went back to single judge for reconsider for trial and for trial and all of that. But again, I highlight both of these from a patent perspective is because it highlights how courts are adept at understanding the nuances of these issues of law, and this can go both up and down at times. You'll win some, you lose some, but that's one change that's happened. The second change, and I'm now going to talk about some procedural changes, is that in India, and then let me explain it in a way that students would perhaps understand. As an associate, if you do litigation, one of the things that you would do is ensuring that once your lawsuit is filed and summons are served, you do service either through the coordination with your office people and everything like that. So I remember in 2015, about 2 years in, I had to serve a defendant in this particular country on the east side of the globe. And I had taken out their address from the website or whatever publicly available domains, and I'd given it to my courier person in the office, not for someone, for our compliance, the lawyer's compliance that they have to do, right? And he would call me back and say, the address is wrong. I'm like, how can the address be wrong? The address is on their company's website, but no, they're refusing to take it at this particular country's port. And I remember having a very detailed argument with that person. I mean, dude, it's the only document I have. If you're telling me the address is wrong, there is no way I can serve the person. So then he will not get served, then he will not turn up in court. This litigation will unnecessarily prolong. So one change in that context, especially for all junior lawyers out there, is the fact that now we have WhatsApp service, which was introduced by the Delhi High Court rules, original side rules in 2018. We have various other changes. We now have situations where the procedural law has changed. And when the procedural law has changed, you have a situation where you have to adhere to very strict timelines. If a written statement is not filed in a lawsuit in within 120 days, the right is forfeited. Now, earlier, even if you filed a written statement, which is the pleadings in a lawsuit, you had this separate process of called admission denial affidavit. So supposing if I filed, say today, 20th May, I would file a written statement. Then, when the matter comes up on 22nd of May, then I'll get another 4 weeks to file my admission denial affidavit. The matter will come up in July. That'll take me till August or September for both sides to file admission denial. The other thing the court did was they clubbed this process of admission denial with the filing of the written statement and the response to the written statement that a plaintiff files, which is called the replication. So you club the procedural stages. Then you change the manner of adjudication. There in certain cases where a defendant does not have a defense of no prospect of succeeding, then there is this concept of summary judgment. And it can happen in trademark cases. I did one of those cases just after we got out of COVID in 2022 for a very big multinational trademark dispute where we had sued someone and they didn't have a defense. So we moved an application for summary judgment. We argued it and we got a relief. We got the trademark declared as well known also and got summary judgment and kind of saved the client's cost in terms of going for a full-fledged trial. So I think over the last decade, these changes have predominantly come out through the Commercial Courts Act, which recognized in IP as a commercial law dispute, changed the periods of litigation, the stages of litigation. On top of it, the Delhi High Court rules came in, which spoke about WhatsApp as a service. Like I told you, I've just sort of taken you through the examples of the changes that took place rather than telling about the act. And the final change, and these are the big three changes that I'd like to talk about, is when the IPAB got abolished last year. Then in that scenario, now we have set up the intellectual property rights division in the Delhi High Court. And what that ends up happening in very simple terms is that now not only do we adjudicate upon issues of IP infringement at the Delhi High Court, but even appeals arising out of the registry, they also get adjudicated upon in the Delhi High Court. So we've actually had a case of a trademark appeal, two trademark appeals that got filed and decided and heard and a judgment rendered within 36 days. So it's been a lot of change. And just to contextualize this for students who might be listening, for someone who might be practicing in litigation, these changes are rapid. There are a lot of changes that keep happening. You have to be very clear about your timelines. You have to plan. Of course, people in litigation tend to only think of the next day and respond to the deadline of the next day. But I think it also requires you to plan out a little bit in advance. I tend to do that more than probably is required, maybe, I don't know, but I tend to do, because you have to have a macro view of which matter is coming up when, and also a micro view in terms of what you're supposed to do for tomorrow. It's sort of a balance of both with these kind of changes that happen, because courts are very clear about these timelines.
The way you are explaining all this, you are meticulous. It is proved, and we don't need any more proof than you remembering the dates and days and year and everything. It's not that easy, and somehow you have maintained that particular thing of knowing all these things and remembering it. It's commendable, to be very frank. I would like to ask you, as you were talking about your LLM, I want you to elaborate a little bit on that as well, and the kind of difference that you saw in between the study process as we see in India and as you saw in US as well. So you can give a comparative analysis also. And the kind of difference that you saw when you came back from doing your LLM and rejoining, the thought process must have changed. Something must have changed as well. Would you like to share that if possible?
Of course, of course. It's an excellent, excellent question. I think before I answer the differences and the change, I think one fundamental question I also want to address first for all the listeners is when to do an LLM. The answer to that is a personal choice. That's one. Two, an LLM is as valuable as you make it out to be. One of the most fundamental things that I want to talk about LLMs is that it is how you use the program, and the program that you choose and the professor and course combination that you choose and how you spend your time defines your LLM experience and will also define your time after the LLM. Now, whether you want to do it immediately from college or if you want to do it after work is your personal choice. I chose to do it after work for a variety of reasons. Reason one, you have better clarity of where you want to do an LLM when you do it after work experience. Probably 2 to 3 years, not perhaps more than that. 2 to 3 years of work experience is good enough, ideally, minimum at least two. Because what that teaches you, it teaches you how to live in a little bit of discipline, handle certain stressful situations, handle deadlines, and it also clears up your mind after being in practice for some time. And what could happen is, supposing I may be doing practice in area A, I may decide to do LLM in area A. Like, for example, I was practicing intellectual property and I decided to do an LLM in intellectual property because my practice confirmed to me that I want to go and do an LLM in intellectual property. It could have gone the other way around as well. I've just explained my IP journey and how I reached intellectual property. It could have very well been for 2 years of 3 years of intellectual property practice. I could have come to the conclusion, no, I'm not enjoying intellectual property, and I could have done an LLM to shift away from intellectual property. So always after work experience, that's one advantage that you have. Second is that the overall LLM experience is also very different from after having done some work experience, because then when you reach your LLM college, you don't get enamored by, oh my god, this is a tough professor, oh my god, this professor doesn't grade well, or this assignment is tough. You're able to handle things on their merits, on their substance, without really getting boggled by or bothered by, will I get the marks, will I not get the marks, because you're in tuned with the subject and what you want to learn. And I think that clarity comes out better when you are coming with work experience. Second point on the first point that I highlighted was the fact that also doing work experience helps you understand which LLM college do you want to really go to. I had a couple of options, but I ended up going to Boston University School of Law and I did the LLM and IP program over there, and a niche program that too, where you didn't even become eligible to qualify the US bar exam. And that was a conscious choice. And I actually had a conversation with one of the leading law firms in the US where they were having an informal interaction with me. And they asked me that, we've come across many Indian lawyers who come to America, and you're the first one we've come across who doesn't want to give the bar exam. And you've not even chosen a course where you want to give the bar exam. I was like, because the point is that the kind of job that I have done in India, or the kind of exposure that I have in India, for me to get that equivalent experience in America, I will have to spend 3 to 5 years. Maybe I was wrong, maybe 3 to 5 years or less, but I have to spend some time to reach the equivalent position in America. So for me, the bar exam was not mandatory. It was more important for me to learn intellectual property. And I ended up doing a lot of these different courses. I did a course on trade secrets law. I did a course on food and drug administration, FDA law. I did a course known as IP workshop at Boston University School of Law, which is where I critiqued leading academics and we had to critique their respond to their papers. And I remember this was the Oracle Google dispute regarding those Java APIs, the copyright dispute the US Supreme Court decided in favor of Google a couple of years ago. And I wrote a paper favoring the copyright owner in that, opposed to all the other things, because I went into the entire history of that dispute and sort of prepared that. And why I'm bringing up that is in terms of differences, in terms of takeaways. that course, that seemingly academic course, which is IP workshop, which when you read the description on the website, it feels like, "Arre, this is just an academic thing. I'm in practice. Why would I want to spend my time responding to a professor's paper and respond to it? And why engage in such an academic activity?" But that paper, I mean, I did 6 responses over a 4 month semester, 6 response papers. We did about 6 papers. That one course taught me to understand the underlying argument that the opposite side, the paper that I'm reviewing, is making, and then to formulate my argument by understanding the underlying argument. And that one skill that I picked up by doing that course has helped me throughout, even helped me in the Monsanto decision when I came back to India. So that's a partial answer to what was different when I came back in terms of the skill that I had learned in the law school. The other difference is that in America, it's very simple. If you have 1 hour of class, if you're a fast or an average reader, you need at least 3 hours outside to study. That's in a way, it's simple. So, for example, if I have 10 hours of class time in a week, it's called 10 credits, which is also quite intensive. That means I have 10 hours of class time. Then that's 3 into 10, 30. So that's 40 hours only studies. That's an 8 hour every day if you're going Monday to Friday, only studies. And you have readings assigned for each lecture. The professor doesn't go through each reading. The professor will ask you questions based on the reading. There are days, sometimes they have on days where you're mandatorily supposed to answer. There are days when you may not have to answer, but if you know the answer, you can answer. But if you don't do your reading, and if you don't turn up in class well prepared, they will move on from the topic. Then it's gone. Then if you've missed that, then you have to go back, finish the readings, listen to the class recording, and then kind of figure out your understanding. So in America, if you have to study, at least you have to be on top of your readings to the best extent you can so that you learn along the way. And if you do that, then your professors will push you. For example, the food and drug law course that I spoke about, my professor actually pushed me on this paper of comparing the biologics or type of drugs in India, the biologic and biosimilar regime. And she kept pushing me in terms of it. Instead of an end semester examinations, I spoke to her in the first week of starting the course, and we had an interaction. And she's an authority in the food and drug space. And I ended up writing a 70-page paper in that exam, in that course, not because I was planning to write it. I was definitely not. And because she was not assessing me on an end semester exam, and it was a continuous sort of an engagement, she would keep giving me deadlines. She was like, "No, no, I like the discussion. Why don't you come back with a title next week?" So I went back with the title. Then, like, "I like the title. Why don't you come back with an abstract next week?" Like, "Okay, fine, I'm coming with an abstract." Then she's like, "Now that you've got the abstract, why don't we get this informative portion of the paper? We'll come to the analysis." So, there's a very different sense of engaging. So that's the academic side. The other very important aspect of the LLM, and the academic side is predominantly you getting investing yourself in your education and your academia and in your studies. The other side is the exposure outside the classroom, which is meeting people from different countries. I made sure in orientation, and orientation is meant for you to meet your batchmates, and this happens across any law school that you may go to. I made sure I met every single batchmate in the orientation. I went around, kept meeting everyone. As it turned out, my friends became friends with each other, and my closest friend circle ended up becoming 16 people from 11 countries. And I remember that even with all the craziness and studies, we ended up doing 3 trips. We ended up going to Mexico in a spring break with half of that group, about 7 people. Then all 16 of us went after our exams got over, and our parents went back after graduation, or no, just before graduation, after our exams ended and before graduation. We ended up taking this big house in Cape Cod in Massachusetts, and 16 of us. I don't know how we found a house as big to fit 16 people, but we found a house where 16 people would fit in. And it took us at least half an hour to see the entire house also. And I remember this scene as the last thought for people who are thinking about LLMs, right? So we entered that house sometime in May, which is just again around this time we're doing this interview. And the American winter had just ended, or summer was still not there yet, because American summer starts in July. So it had started just becoming a little warm, and the 16 of us landed up there. And for some reason, we landed up there at 11 or 12 in the afternoon. And for some reason, till 7 p.m., no one had entered the kitchen. But at 7 p.m., everyone started feeling hungry. Then we discovered the stove doesn't work. So then we called up the guy through whom we had booked up the room in a panic, and the person who arranged the room for us was panicking, like, no, no, but I can send you someone, but the person doesn't speak English. So we responded by saying there are people from 11 countries here. You send them over. We'll figure out whichever language it is. There'll never be a problem. We'll manage. I'm sure that he also never met so many people from so many countries. So I think that's the final thought that I want to leave with you for the LLM. That it's a wonderful experience. It teaches you a lot of skills, and eventually it is the friends and the big ideas. Now it's been 7 years since I finished my LLM, and I'm still in touch with my alma mater, BU Law. I also spoke recently there as well. And the short point there is that even after so many years, we had a reunion also in 2019. So the point is, in so many years, you make great friendships. My LLM books right there. I know when to look at them when I want to pick up. There are times when I'm stuck in matters and I go back to that book and I look for some answers. There are matters that I recently got 1 or 2 years ago which directly applied what I did in my LLM. I just spoke about the IP workshop and how it used to apply to my thing. So a lot of it just happens consciously and subconsciously. And of course, you build a very good network, you get a lot of opportunities. A take back from an LLM is, it's not like a checklist that I will definitely get this. It has to flow and it'll grow on you what you take back. But if you're definitely considering an LLM, you must be clear why you're doing it, how you're going to use it, what is the professor and course combination that you're going to take, and studies, everything aside, you also have to enjoy. My schedule was set. I used to study from Sunday to Friday evening. Friday evening, I used to have fun with friends. Saturday used to be morning house chores and a little bit of studies. Saturday was again time with friends, and then Sunday all padhai. So those two evenings, Friday and Saturday evening, every single weekend we had fun. Every single weekend. That is starting from September all the way till we graduated. I now feel like I think I've done enough of hanging out with friends than I need to, because that was a lot.
Wow, what a fascinating journey you have been through. And I don't know whether you plan it or it just happens flawlessly for you. You just get in the best possible manner the output from whatever you do. And that I can say from my experience with you about AI and law and AI and IP. And now my next question will be around that. As you enjoyed your LLM, as you have enjoyed your work with Anand, and the way you have taken it up, that IP should be the priority for you, and IP has become kind of a niche, and you are authority now. I want to ask you, how did you end up loving AI and law also, AI and IP also in the same manner? And what prompted all this? Because you started doing it way back when no one was even talking about it. And also, please give your perspectives about the kind of impact that we already are seeing because of AI on IP, and probably something which you can see in future with the kind of experience that you have.
Thank you. Thanks for that question. My tryst with AI is something that even at my workplace, I mean, considering how passionate I am for IP, people and sometimes elsewhere also are surprised in how did you like just get into this? I think there are a couple of things. One fundamental thing is curiosity. I've always been curious and I was intrigued by AI way back in 2019. This is just about 2 years after my LLM. Second is there is my brother-in-law, my Jijaji is very well involved in AI in that sense. So I would again, just like I had one Mosaji who was speaking on IP, I had a Jijaji who just sort of mentioned AI in the room. And it also happened in 2019 that Mr. Anand ended up having a moot court where he was looking at AI issues. So I ended up also having a conversation with him in AI. That is a little bit of a background, a little bit of a background in terms of how I became aware of, oh, there is something like AI. I think the turning point really came during the COVID lockdown, I think, because we got a little bit more time. Everyone really got time. It was a very tough period for those 2 years. And what eventually happened was, and very practically how this happened, was that at some point of time after work, I stopped watching TV. I think by mid-April, I mean, I think lockdown hit about mid-March 2020. By mid-April 2020, I was pretty much done with binge watching out after work. And then that time started going towards reading, and I came across this particular author, and I've written to her also and informed her of this. She knows this actually, a lady called Karen Howe. She used to write for MIT Technology Review at that point of time, and she used to publish a weekly newsletter called Algorithm. And I started reading her articles. Then, of course, I had a couple of interactions with my brother in law. And then from there, I joined this community called MKAI, which at that time was called Milton Keynes Artificial Intelligence. And how it happened was that I was reading up on current house articles, I was reading up on AI generally, and then I ended up joining this community which were holding weekly events around AI. And I was like, this is interesting. I mean, this is what I'm reading, and these guys are talking about it. And then they had this mechanism of joining a WhatsApp group where you would have conversation on AI. And this is around November 2020. And I think it just rolled from there, because what ended up happening from there was that we would along with work and all, once I would be done with work and I would spend time with family and all, I would spend about an hour and a half on that WhatsApp group. And in India, I mean, one would seemingly just spend 1.5 hours on WhatsApp just like that, right? So I would consciously spend, I remember, instead of watching TV, I would sit in my lounge, and because one couldn't really step out, do anything, right? So just to take a break, I would sit down, I would see the entire group, I would see each message, I would respond, I would read, I would share my views. And that happened for a good period of 6 months. Then Richard Foster Fletcher, he asked me to become the voluntary head of community at MKI in early 2021, which role I took up till the end of 2022, till we got out of COVID and we were back in action in that sense, in the pure sense. And those 1.5 years with MKI, we did a lot of LinkedIn lives. So I was a lead panelist in most of those situations. And what happened was, this is more like a, I spoke about my LLM. My journey with MKI and AI was predominantly like a, should I call it a long distance LLM, an interactive LLM, or whatever it was. But every month we used to have events. And as a lead panelist in the LinkedIn Live, I had to read up and I used to read, and it sort of just snowballed from there. And I got interested in AI ethics. I got a very good book. There was an AI ethics by MIT Press. I'm forgetting his surname, book on AI ethics. There was a book on machine learning, which I read. Then there was one more book, Transforming in the Age of AI, which I'd earlier started reading in 2020, just before COVID. And all of this is coming from curiosity, really. So it's sparking the interest. And then from there, there was this another Springer journal called AI Ethics. So they were looking for peer review members, and I got nominated on the peer review board there. So that sort of introduced me to AI ethics. So we had MKI, that was all AI. Then we had AI ethics. Then, after I became voluntary head of community at MKAI, which went on for 1.5 years, I am now and have been since then at For Humanity, which was even closer. So MKI was general AI, which is a fantastic community for anyone who wants to really get into AI and find their feet in AI. It is, and I maintain it till date. If I am in AI, it is because of what and how I spent time at MKI. There's no doubt in my mind. And the circumstances were such, so things just happened. And then from MKI, I moved to For Humanity, or rather with MKI, I was at For Humanity. And For Humanity was slightly closer to home, because at that point of time, For Humanity was building an audit scheme on data protection laws in the context of AI systems. And never looked back after that. So with For Humanity, we launched Co-Lead Team India. I'm at Team India. We looked at all India's AI policies way back in 2021. We looked up the national strategy, the responsible AI reports. We created a compendium on that. We then worked on the withdrawn data protection bill to make a AI audit scheme. Then I think in 2022, we responded to various calls of comments from For Humanity perspective. Then I got in touch with certain industry organizations through my work. And I think it just has organically flown and grown from there. And I think one thing that has played a major role is also LinkedIn. And I'm not sort of advocating the platform in that sense, but I think the platform by itself, in terms of the quality as opposed to other platforms, the manner in which one can share perspectives on that, and the kind of connections one is able to make there. I think 2020 to at least early 2022, which was the period of COVID for me, till I came back to office in early 2022, it was a phase where even LinkedIn and all made a very big difference, because you could share with people and you could interact with perspectives. You could meet people across different parts of the globe. That was pretty much the only way you could meet. And your question was really on IP and AI also. But by the time Chat GPT came in, I had really looked at AI from what is AI, understanding AI as AI, looking at AI ethics, looking at responsible AI, looking at ethical AI aspects. AI and IP at that point of time was just debates on authorship and ownership, which were great. But my approach to it was very different. And then I looked at AI comprehensively, and that comprehensive look at AI, and then sort of getting a data protection angle to it from For Humanity. Then when Chat GPT came into the picture is when some of the commercial work sort of, law firm perspective sort of came in. I remember working early last year on a couple of very good projects where we were looking at Gen AI and IP issues. We also worked with NASCOM. NASCOM reached out to me in terms of providing initial feedback on their generative AI guidelines, and the firm Anand has been acknowledged as one of the contributors to the initial feedback sorted by NASCOM, which they published last year in June. And it led to a lot of other developments. But this is how it has been. And now looking back, I think if I had to again sum it up, again, I think the long answers is that I'm looking at AI as AI. I am looking at AI from an ethical lens, but because I'm a lawyer, I translate ethical AI into responsible AI. But again, because I'm a lawyer, I look at responsible AI from a data protection lens, from an IPR lens, from a security lens, and all those elements of legal that touches in the various concepts of responsible AI. And then, of course, I look at intellectual property. In this process, what ends up happening is that I look at law AI from a non technical legal lens. And the impact on intellectual property, I think the audience will pretty much be aware of various litigations that has been filed. So you have about 43 litigations. We did a study. We had 43 litigations done. I actually did myself earlier in Jan 2024 when I'd gone for a talk to IIT Madras to kind of give them a perspective. I mentioned that I realized that 15 lawsuits had been filed last year in 12 months, seven by book authors, one by photographers, actually two by photographers, then one on hallucination. So generative AI, as it is kicked in, its outputs create all kinds of actionable claims, which has led to a lot of IP disputes. Of course, Anand and Anand did the Anil Kapoor matter, which is more on the personality rights angle on generative AI, which was early last year. I was involved in certain manner in that dispute. And so when you look at IP in terms of output, there are some actionable claims. And of course, the other way of looking at IP and AI is looking at the rights in the AI system. And if you have to break the rights in the AI system, rights in the training data set, rights in the algorithm, rights in the software in which the algorithm is embedded, rights in the outcome, which is all the generative AI output disputes, and perhaps even in the hardware, which is the hardware for our students is another. I'm not advertising this. It's like, for example, something as big as this. Like this is the book on chip wars, right? It's pretty much on. I'm actually reading up on it to kind of figure out more in terms of the hardware element. I understand the hardware element is predominantly more from a trade secret context if you look at IP, but there's more to it. And the journey keeps evolving. As recent as 2 weeks ago, again, I joined an MKAI event where they had an event, and it's an evolving one, where we had a very renowned person called Lord Tim Clement Jones. He came in and he went and spoke about AI policy and governance. And now I call myself someone from a pre-chat GPT generation. And I think he also comes from that perspective. So we had a great conversation and we gave some feedback on what he was thinking. And he's also published a book. So I'm kind of now looking at this one, which is Living with the Algorithm, which is looking at AI policy and governance. So I think it's curiosity that has driven this. And it is consciously choosing how I spend my time. It is looking at AI holistically. And I think focusing from my particular lens. I haven't gotten confused in terms of how I have to look at AI, and I have remained very comfortable that I am doing it from a non-technical lens. So I'm not really looking to become a machine learning engineer or a data scientist, and I'm comfortable in the space of where I am, and I'm letting the journey evolve on its own, and that's how we've reached here.
Wow. So Chip War is one of my favorite books. Yes. Lord Tim Clement, I have read a lot about and I have interacted a couple of times. And I enjoy with every sentence that you make, you have a book to refer. And that's the best thing which I can actually be happy about right now. Why I'm saying so? Because I hardly find anyone who can always refer a book. I love that part. I love reading. I also have all the books in the background, which is Chip War, Breached, and all those books which talk about AI and law from actually non-technical perspective, because you cannot always be thinking about from technical perspective. And as I know you as a person who's trying to demystify AI from non-technical perspective, I want to ask you now about what are the key points that you believe everyone should try and understand about AI, and not only think about it from one perspective but a legal perspective as well. Also, I'll try to add one more query to this, that the people, the students, young lawyers who are already either in the litigation field or IP law, how do you think that they can try and think about pursuing such a career which you are already building for yourself, what kind of things they should look forward to if they are law students or if they have become lawyers?
Excellent questions. I like how the flow of this conversation is really flowing in terms of the different facets you're touching, and I'm just sharing the journey. I think the key thing in this is that there are two parts to what you've asked. One is, of course, what would people understand about AI, right? And the second is, what about students can do? What would I want people to understand about AI? I think the first fundamental point, which is very, very important, and this connects to your second question, is what students can do, is to understand that there is a AI narrative. The AI narrative is built on two aspects. One is what AI is today, and two, what AI may become because of research that is happening in it. If I break down that into two topics of AI, one is artificial narrow intelligence, which is AI being a pattern recognition tool, even if it is generative AI. It is recognizing a pattern and creating an output, which could be an image, it could be a video, it could be a text, but it is still in its black box figuring out pattern recognition to generate the relevant text or to generate the relevant video, right? So there is the pattern recognition tool of artificial narrow intelligence. And the second is this entire concept of artificial general intelligence, which is AI rising to the level of human intelligence and machines and human intelligence being at par and being the same. We are not there at artificial general intelligence. There might be situations where somewhere in between, there might be claims that we are reaching there. There might be research that we might be there very soon. But the point is that we are not there yet. And therefore, as students looking to get into this space, as practitioners looking to get into this space, it is very important to understand what we have today and distinguish it from what may happen tomorrow. Because if you look at what has happened today, you will realize that all laws, even the World Intellectual Property Organization AI and IP issues document focuses on artificial narrow intelligence. Almost all regulation focuses on AI, what AI is today. Even the EU AI Act only amended its definition of AI, making it consistent with OECD only after generative AI came into the picture. So it's important for people to understand that. And finally, if you're looking at AI, you have to understand where all you can see it. I mean, AI is present when you watch a movie. AI is present if you're streaming music on your app or on YouTube. AI is present when you're scrolling on a social media platform. So I think it makes a big difference in terms of knowing and understanding AI in a very simplistic sense. So when I always emphasize a non-technical legal lens, the reason I emphasize on non-technical is to tell people that it's around you if you can see it. And therefore you have to appreciate it for what it is today. The legal element is for you to understand that there will be issues of privacy, there will be issues of security, there will be issues of exploitation of vulnerable users. We only have one provision on children's data in the Data Protection Act that has been passed with respect to that age verifiable consent and the verification mechanism. So there are multiple angles in which you can look at AI. And therefore, as students, you need to be aware of these issues so that you figure out your angle. One last thing is that AI and job displacement is only one narrative. And therefore, when we're talking about AI, I'm not getting into the controversy of AI and jobs. I believe that some jobs would be created, some would be displaced, that with any other technology. That you also have to look at AI broader than that. And only when you see it from a completely holistic perspective will you be able to manage and see the entire thing. Now, my advice to students, I think if they would like to do, I think there are a couple of points, and I've actually made pointers about this to try and kind of be clear in terms of this. I think first, whether they're looking to pursue IP, whether they're looking to pursue I think it's important for people to explore what they really want. You have to have a sense of what is it that you're looking for. When I spoke about my own journey, I came into intellectual property because my professors were good, because I liked, I read a good book, and I kept exploring it on my own. One thing that I notice, especially amongst people, and I interact with a fair number of students, is that just because someone is coming from a very big brand, it must be good. Is it good for you? Is the question. You have to know yourself a little bit. And I'm not getting into the philosophical question of knowing yourself. I mean, people spend lives not knowing who they are. But if you have a broad idea of who you are or what interests you, and from my perspective as a student, which subject interested you will tell you an idea of who you are. What you liked would tell you what you are. What you didn't like would tell you what you are. Which internship or what part of an internship you enjoyed would tell you who you are. So it's very important to kind of have some sense and cues of who you are as a person. And I will contextualize that in the context of my LLM also, because when I was choosing for my colleges, somewhere innately I felt that Boston University School of Law would be one that would work for me the best, even though there were some better colleges or there were some more prestigious colleges in the conventional sense that where I may have gotten admission to, but that it didn't work for me in that sense, and it worked out very well. So you have to really know who you are. I just contextualize to the LLM. The second is, if you're looking at intellectual property rights law, you have to understand it's a niche area of law. And if it's a niche area of law, you have to seek out. I come across very brilliant students, very good at their work in their internships, but then they don't know anything outside, say, a couple of top law firms and IP. It doesn't work like that. When I was applying for my jobs in IP, I had a list up to 15 law firms, all the way from tier one, tier two, tier three. Tier one, what type of job? Tier two, what type of job? Tier three, what type of job? If I get a tier three, how many years do I want to work there? Then which profile I want to shift to? You have to be clear that you have to seek out a niche role. The firms won't come to you. The PPOs aren't in that scenario. These niche firms operate in their own way. Why they operate like that is not, we're not getting into all those kinds of questions. And if you make your mark in IP, or if you reflect IP, we can figure out immediately whether you're interested in IP or not, because we are also niche, and so we can figure it out, right? So that's the second point. The third point is, if you get an opportunity, and I'll come to the AI element of this in a bit, but if you get an opportunity, you have to make the most of it. Then it cannot be that, someone is asking you for urgent research, and that person's indicated to you that, I want it in 3 hours, and then you, instead of working on that research, spent another hour taking work from other people, and then you're like, okay, well, I couldn't do that work because I had taken work from another person. That's one thing that I noticed. The other is that if sometimes the work demands working beyond the conventional hours, and the work demands working beyond the time and an internship would end, you got to do it. I think I can at least count three. I can think of people who got hired in the firm just because they had interned with me. And let me qualify that further. They interned with me, which means that we were working in a very big Supreme Court matter, like I mentioned. Some of them would sometimes work, had to stay up till 3 or 4 in the morning, not every day, but in those times when the matter was being heard in the Supreme Court hearings, because there's no choice, because we were coming back from briefings from senior counsels at 11:30 in the night, and then we had to do all the notes, and then we had to prepare the bag, and then it was, a very big matter, and there were like 20 lawyers involved, and therefore you needed help from interns. And I had one batch of interns helping me in the opening argument stage, and one other batch of interns helping me in the rejoinder argument stage, and both of those interns got hired. What I'm trying to emphasize from that is not this crazy culture about, oh my God, you must work 24 hours a day or 16 hours a day. And that, no, it's about their commitment. It's about the fact that they've understood their job, they understood their responsibility, and not even once did they bring up the fact that, we won't do it, because they understood that there's a matter like that happening. A counter argument could be that, but that was such a big Supreme Court matter. If I get to work on it, I will definitely stay back. And my response to that will be, no, it doesn't have to be something as big, high profile like that. It can be just any task that is given to you. And you have to understand the seriousness of the task and the importance of delivering what is being asked of you. And you have to be very clear of what is being asked of you. Either you do the task and you understand the task, or you and unclear, you ask about the task. But once you've got the task and taken responsibility for the task, you have to deliver it, and you have to take accountability of it. If your approach is going to be that, I'm actually just an intern and I'm not really going to take accountability for my task, and it's okay, it doesn't matter, and even if I don't do it, it's fine, then immediately it's visible. That's the point, that if you get an opportunity, make use of it. And once you make use of the opportunity, sometimes there would be opportunities where you intern, sometimes there will not be opportunities where you intern. Some of it is luck, but that luck also plays a difference. If you make use of your opportunity, even if you may not get the opportunity in the place where you worked at, that person will act as a good reference for you, and then that person can speak to some other person when you're looking for jobs. So there is no downside to displaying that level of commitment. And then the other thing is that you just have to keep working hard. And as far as AI is concerned, I think it's a very open field, and you have to kind of know what angle and what perspective you want to bring in. I think for younger students, for younger people, if they have a very strong interest in technology and policy issues, where they have more time on their hands, my only advice on AI, and for anyone interested in AI, is a very broad one, which they should feel free to interpret on their own. which is that if you're looking at AI, if you're looking at technology issues, play to your strengths. Play to your strengths. And that's what I've done at least. I stick to the non technical legal elements, I play to my strengths.
You have brought in such an important aspect of respect for the job and respect for the person who's actually giving you that particular work to be done. If you do that, you definitely will have an option of getting hired or getting a PPO even where you are doing internship. I guess that is one of the very important perspectives which you raised. And somehow that does not show that you have to actually work for 18 or 16 or 20 hours. But the only concept which I saw from here is to be respectful and to be mindful of the sequences or consequences which are going to happen. The importance of matter does not come from whether it is in Supreme Court or High Court. It is supposed to be understood in a way that how important it is going to be for your career as well. Because if you are assisting, you will be acknowledged. That's what I took from what you suggested. And I may be wrong, but that's what my understanding was. It is very important for students to understand, and that's the thing we want to convey here as well. We almost have gone through the whole interview, but I have not yet asked you one of the very important questions about personal life, where how do you manage that particular balance? Being so busy with your reading, with your work, with your job, how do you balance that? And what are your suggestions to such people who actually feel like we don't get time for personal life? So, how have you done it so far, and how do you see that others can also follow your footsteps?
Work life balance is an important topic. I think most importantly, post COVID, especially. For me, to be very honest, it is because of my parents and my family, friends, and of course, my wife. Initially, my parents, before I got married, because we all live in Delhi. So I had the benefit of staying with them. And litigation is litigation, it takes its time to mature. So that played a very big part, and having to counsel with them and to spend time with them. Came down to the quality of time that they spent. And I think with both of them being doctors, and I have seen them work throughout in life, they work even now. I think my father leaves around 8:15 in the morning, and my mom still leaves at 9 in the morning, and both of them come back by 6:30 in the evening, sometimes later. That I've seen something from childhood. So it's about the quality of time that you get to spend with the people you are. The other aspect, most definitely about after marriage, has been my wife's support. And I think that's about after 2017, 2018, that's where my career has also taken off exponentially with both the Supreme Court matter that I spoke about and getting into AI. I think the fact that she's in the same profession, the fact that she understands, and she is now gone into teaching. She herself was a corporate lawyer at a prestigious law firm. She understands those issues. I think that goes a very, very long way in the balance. And I think the answer to that question, to balance, really is that you have to find your own balance. You have to know what matters to you. You have to consciously invest time in things that make you happy or that help you relax. For me, the work life balance in the COVID period was, like I just mentioned earlier in the interview, was say perhaps reading on AI as a hobby, because one didn't want to watch shows. One, of course, wanted to spend time with family. We used to watch some of the shows with family, but once those shows are done, we used to watch a lot of Crown or some one of the show we used to watch, and then I would spend time in sort of reading AI. Then, as I stepped out of COVID, balance then came in with spending time, maybe stepping out and watching a movie, or maybe even binge watching a couple of movies, or we used to go for a movie early Saturday morning. So the concept of balance keeps changing. Even my sister-in-law, she is a teacher, so all of them are working in our house, and we have a dog who makes sure that everyone's happy. So I think quality of time that you end up spending in your free time makes a very big difference in balance. Also, finding time for yourself is very important. I think having some time to connect with yourself is very important in part of that balance. And I think saying that you're not able to find time for yourself, saying that you don't have a work life balance, also does not help. So you have to first structure it. And I think the most important point in trying a balance is I stay very disciplined now. I leave for work between 8:45 to 9, irrespective of whatever time I may have come back the night before. And I make sure that even with litigation and all of that thing, I make sure that if it's not urgent, at least I am leaving work by 8:15 in the night, so that at least I can come home by 9:15. so that at least between 9:15 to 11:15 in the night, or 9 to 11:30, at least I have 1 or 2 hours at home. But now, where those hours go into spending time with mom, dad, spending time with my wife, watching a movie, watching a show. But at least that predictability comes in with a lot of discipline. And that has been a very key feature in managing it. So it's very personal. Family and friends make a very big this thing. And I think when you're living this kind of a life, I think your work life balance without acceptance and understanding from a family is very difficult. I mean, at least the way I have looked at it. And I think it's important to also be very transparent in terms of what your priorities are and where you want to focus your time to kind of figure out the way forward.
Thank you so much, Vibhav, for bringing in such beautiful perspectives to this conversation. Yes, work life balance, you have beautifully told that the way you have done it is because of discipline. The way you do it is something to be followed. And I hope our learners and listeners will see, and also I hope that they will reach out to you, because you are such a sweet person who will respond almost to everyone. That much I know. And thank you for being a community builder for us lawyers, for AI and other aspects, and bringing it down to India and to make sure that it reaches the masses as well. And finally, thanks for agreeing to give this particular interview. I hope you enjoyed the interview. And again, thank you so much.
It's been my absolute pleasure. I have just shared my perspectives and more than happy to listen to anyone, any questions. And you're right, I do respond to everyone almost who reaches out to me. So there's absolutely no problem. Anyone is confused, if there is anything they have questions, they want to ask more, happy to converse. So thank you so much. It's been an absolute pleasure interacting with you.
Thank you so much. And kindly reach out to Vibhav. He's always ready to help anyone and everyone. Thank you, Vibhav.
Thank you. Thank you.